The big story on India Upfront. Ever since consultation started on the Uniform Civil Code, multiple reasons have been furthered to stall and oppose it. But there is one excuse which was missing so far. And let's be honest, I was almost beginning to wonder how had someone not brought up the familiar genie out of the bottle yet? The threat of Hindu Rashtra. India is going to turn into a Hindu Rashtra. But if you were disappointed so far, it has happened today, where intellectuals, politicians united with people like the Jamiyat and the All India Muslim Personal Law Board to warn that Hindu Rashtra is landing in India and UCC is going to be the runway it will rumble in on. Within a span of 24 hours, the All India Muslim Personal Law Board raised the banner of revolt against quote-unquote majoritarian morality. The DMK predicted that the common code will be a weapon to beat the BJP's detractors with, and that Sanatan will be imposed. That's what the Chief Minister of Tamil Nadu said, that Sanatan is being imposed on everyone in India. And finally, a Nobel laureate predicted the advent of Hindu Rashtra.
அந்த பொது சிவில் சட்டம் என்பது நாட்டிலே ஏற்கனவே சிவில் சட்டம், கிரிமினல் சட்டம் என்ற சட்டங்கள் இருக்கிறது. ஆக அதை நீக்கிவிட்டு பொது சிவில் சட்டமாக கொண்டு வந்து பாரதிய ஜனதா கட்சியுடைய கொள்கைகளை அந்த ஆட்சியை எதிர்க்கக்கூடியவர்களெல்லாம் பழிவாங்க வேண்டும் என்கிற நோக்கத்தில் மக்களுக்கு துன்பங்களை, கொடுமைகளை கொண்டு வந்து சேர்க்க வேண்டும் என்கிற அந்த தீய சக்தியோடு இன்றைக்கு அவர்கள் செய்து கொண்டிருக்கக்கூடிய இந்த காரியங்களை எல்லாம் பார்த்து கொண்டிருக்கிறோம்.
अभी तो जिस तरह एक मेजॉरिटेरियनिज्म का दौर इस मुल्क में चलाने की कोशिश की जा रही है, शक तो होता ही है कि इनके इरादे सही नहीं हैं, लेकिन इन लोगों को ये भी समझाना पड़ेगा, लोगों को, इस मुल्क के आवाम को, कि जब आज़ादी के बाद मुल्क के कानून बनाए जा रहे थे, उस वक्त सुनने में आया है कि पंडित जवाहरलाल नेहरू उनके साथी चाहते थे कि मुल्क में एक यूनिफॉर्म सिविल कोड हो. उसकी मुखालफत संघ परिवार ने की.
संगे এটা যোগ নিশ্চয়ই আছে, এবং কিন্তু হিন্দু রাষ্ট্র তো ভারতবর্ষের একমাত্র এগোবার উপায় নয়.
So first, let's start with a few facts which unfortunately get lost in this haze and shouting over UCC. The Uniform Civil Code is not going to affect only the Muslim population of India. For example, among Hindus, it may lead to the scrapping of the Hindu undivided family concept that gives tax breaks to those who live in undivided families. Hindus availing of this get a tax exemption limit of 2.5 lakh rupees per year, and also on insurance and capital gains. A common code may lead to removal of the Anand Marriage Act for Sikhs, Parsi Marriage and Divorce Act for Parsis, and the Indian Christian Marriage Act naturally applying to Christians. All of these different marriage acts have so far been claimed as preserving the distinct identity of Christians, Parsis and Sikhs respectively. By the way, now let's take a closer look at how Hindus do stand to get affected. This Hindu undivided family benefit that I spoke about. For this, you need to take a look at more data. For example, in 2012-2013, there were 2,89,000 individual taxpayers in India. Of these, 8,40,000 availed tax benefits of HUF. In 2014, this rose to 9,40,000 out of a total 3 crore plus individual taxpayers. And then in 2018-2019, the figure of HUF beneficiaries stood at 11,30,000 out of a total of 5 crore 52 lakhs individual taxpayers. But the point is that this is not about safeguarding Hindu tax benefits or safeguarding Muslim religious exceptions. The UCC is about equal laws for an equal modern society. The facts are in front of you. Then the question is, why is the bogey of UCC resulting in a Hindu Rashtra being floated? Is the effect of UCC on non-Muslims deliberately being obfuscated in order to create paranoia about what essentially remains a purely legal question. Let me go across our panel. Joining us, lawyer Vishnu Jain, Dr. Zeenat Shaukat Ali, director of the General Wisdom Foundation, Asif Sohail and Syed Asad Abbas, both political analysts, and Maheshinder Singh Grewal, Vice President and Spokesperson of the Shiromani Akali Dal. But I first want to go across to Dr. SQR Ilyas, who is the spokesperson of the All India Muslim Personal Law Board. Dr. Ilyas, the 74-page submission to the Law Commission by the Muslim Personal Law Board, among other things, says the following: majoritarian morality must not supersede personal laws, religious freedom and minority rights. How did you link the Uniform Civil Code to majoritarian morality?
The issue is this. Basically, why Uniform Civil Code is needed. Let us debate this question first.
Sir, if I could just...
Civil laws, for example, IPC...
Sir, very, very humbly, because we could end up going in all different directions, I am starting with your statement of the All India Muslim Personal Law Board. So, when the statement says majoritarian morality must not supersede personal laws and minority rights, how is majoritarianism being linked to this? We'll try and get back to Dr. Ilyasi in just a second, but let's open this up. Let's open this up and bring in Asif Sohail and Syed Abbas as well. Syed Abbas, would you care to answer the question? What does this have to do with Hindu Rashtra or majoritarianism? I think we have Dr. Ilyasi back with us. Sir, why majoritarianism?
You are asking me or you are asking somebody else?
I'm asking you, sir, Dr. Ilyasi.
Yes. So actually you have picked up one issue from the entire the thing which we have submitted to the Law Commission, that is 100-page document. Anyway, I will come to this your point.
Yes.
When we say majoritarian morality, you know, if you go through the Uttarakhand, the silent feature of the Uttarakhand Uniform Civil Code, which has been published in different newspapers, there itself, whatever they have suggested, that directly connected to the Muslim personal law. Secondly, while deliberating on this issue, when the Prime Minister was making a speech in Bhopal, there also he linked the Uniform Civil Code with Muslim personal law or Muslim issues, when he talked about that the opposition parties are misleading Muslims and so on and so forth. And the thing is that it is not only Muslims, the Christians and the Sikh and Adivasis, everybody has said that it is not acceptable to them. So it means that only one community which has not so far objected is the Hindu community. They have not objected, means they think that it is not going to affect the Hindu code bill. For example, if you see, even the optional Uniform Civil Code, which is there in the form of Special Marriage Act, there also, if two persons are marrying, Hindu and the male and female, though both are Hindus, then on them this undivided family law is there for them.
Exactly.
And if both the persons are Muslims, then the undivided family law will not apply to them. So it means that whatever law you are going to formulate, that means majority culture, majority religion, majority customs will prevail there. Definitely it is.
But sir, why are you preempting that Hindu undivided family benefits will not be taken away? Maybe Hindus are not opposing because they are in favor of uniformity for everyone, despite the fact that their Hindu undivided family benefits will be taken away.
You have so far. No. The thing is that when you have formulated the Special Marriage Act, you have not taken away the Hindu undivided family. It means it is obvious that you don't want to affect the Hindu community.
But sir, now it could be taken away. We are all in the realm of suppositions.
How do you say, madam? How do you say? You are not going to frame the law.
But sir, the same way neither are you going to frame the law, but you are already saying that majoritarianism will be imposed on Muslims in the country.
We have the apprehension. we have seen in many cases whenever the bill or whenever the act has been passed by the BJP, for example, you take the case of CAA, they have discriminated the Muslim community. They have taken away Article 371 because the majority in Jammu and Kashmir are Muslims.
No, sir.
So why they have not taken away Article 371 from Himachal Pradesh and from other states?
I would not want to diverge into that particular debate, because then we will be endless. 370 has got nothing to do with Muslims. Jammu and Kashmir wasn't a Muslim majority state to begin with. There were demographic change. But anyway, let's not get into that. Let me ask you more specific question, Dr. Ilyasi. The Muslim Personal Law Board in its representation had cited Dr. Babasaheb Ambedkar at the end of the UCC debate, but isn't it also important to note that he spoke against the immortalization of personal laws? He had said, and I quote, "I personally do not understand why religion should be given this vast, expansive jurisdiction so as to cover the whole life and to prevent legislature from encroaching upon that field. After all, what are we having this liberty for? We are having this liberty in order to reform our social system, which is full of inequities, discrimination and other things, and it is in conflict with our fundamental rights." The framer of our constitution said it is in conflict of our fundamental rights. Why did you ignore that part of Babasaheb Ambedkar?
The thing is that our fundamental rights guarantee in Article 25, 26 and 29 the religious rights as well as the cultural rights. And Article 44 is in directive principle, which is not enforceable by the court. And there also it has been said that the state will endeavor, means they will try to build a consensus for the Uniform Civil Code. It had not been asked to the state that they enforce a law on all the people in the form of Uniform Civil Code. And when other laws are not uniform, why you want to make only customary law on the family laws and the personal laws uniform?
But sir, the criminal law is uniform.
Secondly, one more thing I want to say.
The criminal law is uniform for everyone, irrespective of community.
No, it is not. No, it is not. No, it is not, madam. State to state it differs. CRPC differs. IPC differs state to state.
There are 100
amendments have been made in that law.
But it is not differing for communities. This is according to religion. Personal laws are different for religion.
Yes.
You are bringing it state-wise, but not subservient to religion.
Okay. It is not the matter of state to interfere in the religious affair.
But sir, the same thing was argued for the Hindu code.
By the constitution of the country.
Sir, the same was accused for the Hindu code. At that time, Hindu Mahasabha had objected, and yet the Hindu code was brought in, because the state does, when it is an issue of public morality and law and order, the state does interfere in matters of religion and personal lives. There is precedent. It's happened with the Hindu code.
The thing is that when you say Hindu code bill was drafted by the parliament, again I want to say that so many exemptions were given to the in Hindu code bill to the different communities. They have been satisfied. For example, suppose in South India, a uncle can marry his niece. But it is not possible in Northern India.
But sir, how do you know that will not be
given in the Hindu code bill? Hindu code bill is not uniform.
Correct. How do you know that will not be now made uniform when the Uniform Civil Code, there will be no Hindu code, there will be no personal law, there will be Uniform Civil Code. That is the whole point. And yet we have no South Indian standing up and saying, oh, this particular practice will be taken away. That is why uniformity is needed. You are right. There are some regressive practices, even in Hinduism. They'll be done away with.
What is that uniformity? Then what is that uniformity you want to bring? The thing, one more thing I want to spell out here. Actually, as far as the Muslims are concerned, you know, Muslim personal law is derived from Quran and Sunnah. It is not made by individuals. It is not made by ulemas. It has been prescribed by Quran and Sunnah. And it is an integral part of Sharia. It is not the case with other communities. Their personal laws were not derived from their books. So this difference you must try to understand.
Sure, sir. But let me then ask you, if only personal laws, and this is again something that the All India Muslim Personal Law Board had said, that this is integral to our religion. And for secularism, I'm paraphrasing what you said, that for India to be secular, personal laws need to exist. Then is France not a secular country?
Yes.
Is the UK not a secular country? Because there are Muslims there and they do not practice personal law.
You know, don't try to compare France and UK and USA with India.
Why?
You know, if
we're
you
all
go
secular
through
democratic
other
countries.
States, then you
we're all secular democratic countries, sir.
Then madam, you must take into consideration USA also, where every state, 52 states have different personal laws, and that has not affected their integrity.
But even there, Muslims don't get to practice personal law.
They don't need a uniform civil
even in
code
the United States,
country.
Muslims don't get to practice their personal law. And yet it is supposed to be the biggest, largest democracy in the world.
Even in United States.
And has a secular character.
Just a minute, madam. Muslim practice personal law even in United States, in UK and France. Because unless there is a dispute arises and they go to the court, then only the question of uniform civil code comes. If I practice my religion in my house, nobody can interfere.
Of course, whatever you do inside your house, but whatever the legal status is, let me bring in Vishnu Jain as well. The legal status is what matters. Do you think there are loopholes here which are being exploited when we define the introduction of UCC as Hindu Rashtra? Like I said, is France then a Christian Rashtra? Is America also a Christian Rashtra? Vishnu Jain?
I was very patiently listening to my esteemed brother Mr. Ilyas, and I want to ask a question with utmost sense of responsibility. Whether female genital mutilation is a matter which should be protected by any religion, whether bigamy or polygamy is a matter which should be protected by any religion, whether child marriage is a matter which should be protected by any religion, whether halala is a matter which should be protected by any religion, whether a Muslim woman having no right of divorce, no grounds of divorce must be protected by any religion, whether Muslim women not getting equal share in rights of inheritance must be protected by any religion. Now let me tell you, Padmaja, and I am speaking with a lot of sense of responsibility, the United Nations and UNICEF has said that the female genital mutilation is the most heinous crime which is happening. It is drawing the attention of the Honorable Supreme Court before the 7 judges bench. But the point is they are taking defense of their personal laws. Let me tell you, and I must quote Khalidur Rahman versus State of Kerala judgment. A minor was raped, and when the matter was booked, when the accused was booked, the argument was that it is permissible under our religion. Kerala High Court for the first time in a historic verdict said that POSCO Act does not give exemption on the basis of religion. But 3 high courts have taken a different view. So the point is this, Padmaja, it's not a matter of Hindu Rashtra or against minority community. We as Hindus, let me give you examples. We as Hindus have been codified. Sati Abolition Act 1987, Prohibition of Child Marriage Act 2006, then Hindu Widow Remarriage Act 1856, Section 6 of Hindu Succession Act 1956, giving equal rights to daughters. And till now we are open to codification if there is any regressive practice. No doubt about it.
Answer Dr. Ilyasi. He has,
Mr. Ilyasi feels
he has the fear that just like you took exemptions to keep Hindu undivided family benefits for yourself, Vishnu Jain, you will do it further also. Only people who will be having their rights snatched will be Muslims.
One day give me data, Padmaja. Just 2 minutes I need on Times Now. I will give data that how many tax exemption Hiba has taken. More than HUF. Tax exemptions have been given to Hiba, which has taken complete, they have completely been out of the purview of registration of Act 1908. There is no tax for Hiba, which is an oral gift. And while at the same footing, a Hindu gives stamp duty so far as gifts are concerned. So this is not a question of Hiba or HUF. This is a question of female dignity. This is a question of female justice. And now let me tell you, the right under Article 25 of the Constitution, right to religion is not absolute. It is subject to public order, health and morality. No religion can say that they are above and over the Constitution. My friend Ilyasi sir was using the word morality.
Okay, Dr. Ilyasi, answer this point.
Morality is the word used under the Constitution.
So what is this double standard? This is going on in
Sir, again, I do not want to go into the realm of morality here.
You have not objected to
because then we will get into same-sex marriage. We will talk about live-in relationships. But Dr. Ilyas, really appreciate you joining us. Let me actually end with a statistic before you go. You spoke of how there are more polygamous marriages among Hindus, but you did not mention that percentage-wise there are more polygamous marriages in Muslims. Of course, in absolute numbers, there will be more Hindus in terms of numbers because there's a larger population. As per data, 1.9% of Muslim women said that their husbands had more wives, more than one wife, as compared to 1.3% Hindu women. So it's 1.9% as opposed to 1.3%, but both are wrong. Let us end by saying this. Dr. Ilyasi, thanks very much. Let me open up this debate. Vishnu Jain. We also have Dr. Zeenat Shaukat Ali and Asif Sohail and Syed Asad Abbas joining us. Vishnu Jain, finish your point before I open this up, and Maheshinder Singh Grewal. Yes, finish your point.
I just wanted to make a point that there is a difference between being assertive and shouting. So I think I was being assertive on certain issues which are very core to my heart. The second point is that if there are so many polygamous and bigamous marriage in Hindu religion, so let us all say that it should be banned. Then why All India Muslim Personal Law Board is saying that it is against them? See, the cat is out of the bag, Padmaja. Now they are saying that they are affected by making this law, and they are saying that statistically more of these practices are in Hindu religion. Then let this uniform civil code be brought. Point number 2, I want to give a very interesting example. There was a practice under section 29 of the Prevention of Cruelty of Animal Protection Act. Under that, there is an exemption on the basis of religion. You must know, Padmaja, and I must inform you that 8 high courts have taken a view that Bali Pratha under Hindu religion is unconstitutional and it is in violation of section 29. The matter is drawing attention of the Supreme Court. So that's what I am saying. The legal proposition is that right to religion is not absolute. It is subject to public order, health and morality. In Rajasthan, there was a Tervi Bhoj. That Tervi Bhoj was brought down by the state legislature, saying that the poorer sections of the society are affected by this Tervi Bhoj. And a special act was passed in Rajasthan, which was an integral practice or a custom in Rajasthan. So we are open to all the regressive practices being brought down. And I'm again saying it on your channel that so far as these core issues are concerned, I may not be Mr. Ilyasi said that Mr. Vishnu Shankar Jain does not know about Islamic law. All right, I may not know much about Islamic law as Mr. Ilyasi know, but there are certain factors which I have highlighted on your channel. Female genital mutilation is not a myth. Padmaja, let me again tell you, female genital mutilation is not a myth. It is pending in 7 judges bench of the Supreme Court. I am speaking out of facts and data. Then bigamy or polygamy is not a myth. It is pending adjudication before the Supreme Court.
But the funny thing is,
child marriage is not a myth. It is happening. The Kerala High Court has ruled it.
And the funny thing is that opposition is coming for various reasons from various quarters. Maheshinder Singh Grewal, why does the Akali Dal have a problem with UCC? On the one hand, you've got Islamic bodies saying, oh, this is Hindu majoritarianism. What is the problem of the Akali Dal?
Akali Dal today has constituted 4-member committee to look into the entire issue. But I must bring to your notice that you, as a very well-read person, knowing that a law commission in 2018 submitted a report, and that report was with the government and submitted during the Mr. Modi's regime. And you must have gone through that report also, in which they have said the UCC is not the requirement of the time. And they have gone to this extent that enforcement of UCC can even cause a territorial threat to the nation. This is not me saying. It is a law commission report submitted to the government in 2018. Now it is for the government to tell people that when this report was submitted during Mr. Modi's regime by the Law Commission, why they are now opening this issue.
So
why they have not... See,
so let me just understand. I still haven't understood what is the Akali Dal's primary objection. That the last Law Commission found it unfeasible, so it should stay unfeasible?
I have heard Ilyasi and Mr. Jain also. The thing is not what actually happens, but it's the perception. The perception is that it is going to affect the minorities. India is a multi-linguistic, multi-religious nation.
Sir, how will it affect Sikhs? How will it affect Sikhs? How?
Listen, now the government was taking a credit that they have passed a Anand Marriage Act. That is not even implemented entirely in today also. And that will come to an end. Then what was the purpose of enacting that act?
Sir,
when the BJP took a big credit.
Sir, what is it in the Anand Marriage Act that will not be in a Uniform Marriage Act which will brought in as a part of UCC? What is it?
No.
Name me one feature. What is that exemption, that special benefit in Anand Marriage Act which a Uniform Marriage Act will not have, which you are so fearing?
Yes. Now listen to me. You must have seen Hindu Marriage Act.
Yes.
Hindu Marriage Act says this shall apply to the Hindus. It shall also apply to both these Jainis and the Sikhs. See, meaning thereby that you have accepted the identities of three religions by enforcing Hindu Marriage Act, Hindu Succession Act, Hindu Adoption and Maintenance Act, that you included these three communities also part to which it will be applicable. Now my simple question is, why the Law Commission as of today has not sent these notices for their comments to the political parties? They have today only sent to the religious, intellectuals and others. We have only come to know via media and the press. Just the Shromani Gurdwara Prabandhak Committee, which is a representative religiously body of the Sikhs and which is under the constitution and parliament law, they have already said that the perception is that this act, if comes into force, it will affect the identity of the Sikh as a Sikh, which will not be acceptable to the Sikhs.
Sir, very humbly, is it not true that even now, for the purposes of divorce, correct me if I am wrong, Vishnu Jain, Sikhs also have to use the Hindu Marriage Act? But that doesn't affect your identity. Sir, this is politics. This is not so much about law. Right now, your marriage happens according to Anand Marriage Act. Divorce happens according to Hindu Marriage Act. Did it chip away at the identity?
Padmaji, let me explain. I am a lawyer by profession, I tell you. When we, even under Hindu Marriage Act, we file an affidavit in the court, we must state that our marriage was performed according to Sikh rites by the ceremony of Anand Karaj. We have to write it. Unless we have certificate from the Granthi and the Gurdwara where the Anand Karaj is conducted, the marriage is not registered by even the marriage.
So no one is disturbing that, sir.
Sir, that can still happen. But anyway, I think what has become quite clear, overlooking at the granularities of the opposition, Zeenat Shaukat Ali, is that it is a little in on facts and has a lot to do with identity politics, which is why suddenly after this whole Islamophobia, anti-minority, the giant, the balloon of all threats, Hindu Rashtra has suddenly come up. Zeenat Shaukat Ali.
I think, it is a very sad state of affairs that we are arguing, and then we are arguing in this manner, unfortunately, even without looking at a draft or even telling the government what they want and how to put it across to us and to debate the issue. And when there is the Uniform Civil Code and the article, the directive principles have spoken about it in Article 44, and when it says that, it is an aspiration of the founding fathers, we at least have to give it that consideration, because the main problem, the main crux of that entire debate is that there has to be justice, which is the foundational principle of the in the legal spheres where communities get justice, where it's not only women but even men, and in every sphere of law that justice has to be implemented. And there have been laws which have been overlapping. There have been laws which people are talking about, even in Islamic law, like, which was, I think Mr. Jain brought it out very clearly, that is halala a permissible act under Islam? Is triple talaq a permissible act under Islam? Is putting women into the corner, not allowing them to effect a divorce an act which is an Islamic act, the courts here have had to intervene because the women have gone to courts. The
Zeenat
Supreme
Shaukat Ali,
Court
since
has
you are
been
also a
for this
scholar, let me ask you a very direct
justice.
question. Sorry to interrupt, man. One of the statement of the Jamiat Ulema-e-Hind and Muslim Personal Law Board says the following, that to not allow personal law to exist is in violation of our right to practice our religion. Is personal law an essential part of practicing Islam?
Well, personal law as practiced in India today, you know, which is actually called Mohammedan law. Please understand that the word Mohammedan law is not used for Islamic law. And Islamic law, even in the formulation of the Islamic law, we have applied the principle of fiqh, that is jurisprudence, where human intelligence has been applied. So this entire debate on what is going on and what fiqh stands for. Now, I'll give you this example. All over the world, let us talk about Muslim majority countries which have brought about vast changes in the laws of fiqh, in jurisprudence. There have been changes in marriage, there have been changes in divorce, there have been changes in age of marriage. Let me tell you that in a lot of Arab countries today, women who are 30 are saying that, you know, we don't want to marry till we are 25, till we are 27, till we are 30, till we are not confident. So you see, this entire myth that, you know, this is what Islam is, and what you have amalgamated and put in the form of Mohammedan law, where a lot of customary law and other laws have come into play, to say that that is the pure Islamic law which we are going to, which is going to be, you know, which is being questioned. I think that entire perspective is incorrect.
Incorrect perspective, Dr. Syed Asad Abbas. To try and say that personal law is inseparable from the practice of Islam is incorrect.
I'll be very direct and straight to you, Padmaji. You know, personal law or impersonal law or otherwise, Islam is one, Islam is the same. No number of Islamic bodies or non-Islamic bodies can change it. It is sacrosanct. With respect to, like Zeenat Shaukat Ali ji said, Muhammadan law applies here certainly, Quran and the Sunnah of the Prophet. Now let me speak to you as a progressive Indian young Muslim, Padmaja ji. The fact of the matter, how is India and what is India to me? The Prophet Muhammad speaks of Hubbul Watan, meaning love for the country, live for the country, your life must be for the country. Uniform civil code that we see today, the fact of the matter, let us understand this. On a lighter note, the analogy is such that we are having a debate on something like abhi shaadi bhi nahi hui, bachcha bhi nahi hua. We are deciding bachcha bura hai, acha hai, kaisa hai bachcha, rang kaisa hai, roop kaisa hai, naam kaisa hoga. The fact we are all playing in the air. The fact, let the law come in, let there be consensus, let there be inclusivity, let there be religious leaders,
Mr. Abbas,
let there be non-religious leaders.
That is a great perspective, that you want to look at the draft before making up your mind. That is not a problem. The problem is those who have already gone on record and said this is going to spell catastrophe for the country because this is the first step in the direction of Hindu Rashtra. Like you, even I am saying, आप मुंडन करा रहे हो उस बच्चे का जो पैदा ही नहीं हुआ, आपने उस बच्चे को दानव बोल दिया जो पैदा नहीं हुआ. That is what is essentially happening, Vishnu Jain. The child hasn't been born and you've already said this child is going to be a monster.
The point is, see Padmaja, let me put it in perspective. The Law Commission in its wisdom, the 22nd Law Commission has asked for suggestions from various citizens of the country. Now, citizens of the country can participate in this legislative process. They can give their suggestion. So, as of now, asking that hame draft dikhao is very, very hilarious because we are asking you to participate in this process. If Law Commission wouldn't have asked the citizens, then you would have said that we have not participated before the Law Commission. Now, Law Commission is taking your suggestions. It will be given to the Parliament. The Parliament will also recommend it to the Standing Committee. It will be passed by the Lok Sabha and Rajya Sabha. So, there are a lot of layers where the suggestions and various interpretations by various members of the society will be considered. So saying that draft dikhao won't help, you have to ask a very, very important question that whether your religion, I'm saying that okay, I accept that I'm not an Islamic scholar, but the issues which we are talking about, that whether a Muslim woman has right to divorce, so there are various core issues which I have highlighted in this debate, which has to be asked and where you have to take a stand that whether it is right or wrong.
All right. Respond, Mr. Abbas.
Respected sir, my dear friend Vishnu Jain, very conveniently, my friend Vishnu Jain quotes the Law Commission of today. My dear friend, my dear lawyer, have you read what the Law Commission said in the year 2021?
Okay, again, we've just addressed that issue. We have spoken of the timing. We have spoken of why it is being debated again now. I think hold on a second. I think the more fundamental question that we were trying to address today is that please, if Mr. Grewal has a suggestion, if Dr. Zeenat Shaukat Ali has a suggestion, if you, Dr. Abbas, have a suggestion or Vishnu Jain has a suggestion, please go and submit your drafts, submit your suggestions, but let's not start creating a paranoia about a Hindu Rashtra that doesn't exist or that nobody is trying to impose. Thanks very much, gentlemen, and Dr. Zeenat Shaukat Ali for joining me. But before we go in a lighter vein, since we are talking about Hindu Rashtra, let me quote to all of you a line. You would want to hear this from the statement released by Jamiyat Ulema-e-Hind. They say, भारत जैसे बहुलवादी समाज में, in a pluralistic country like India, where जहां सदियों से विभिन्न धर्मों के अनुयायी अपने अपने धर्मों की शिक्षाओं का पालन करते हुए शांति और सद्भाव से रहते आए हैं, यूसीसी लागू करने का विचार अपने आप में आश्चर्यजनक है। ऐसा लगता है धर्म विशेष को ध्यान में रखकर बहुसंख्यक को गुमराह करने के लिए अनुच्छेद 44 की आड़ ली जाती है। हालांकि स्वयं आरएसएस के दूसरे प्रमुख गुरु गोलवलकर ने कहा है कि समान नागरिक संहिता भारत के लिए अप्राकृतिक है और इसकी विविधताओं के विपरीत है। Who would have thought we would reach a day where the Jamiyat would be quoting Guru Golwalkar in order to oppose the UCC? Anyhow, maybe that's what a great democracy is. Thanks very much, gentlemen, Dr. Zeenat Shaukat Ali, for joining me.